Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now take a look at this. XRP versus SEC legal battle reduced to a defining 15 minutes. Before we move further, there is a new crypto airdrop now taking place on Telegram, which is about to launch anytime soon. Please make sure you participate in this airdrop. The link is in the description of the video. Don't miss out on this. Now let's continue with our video. An attorney named Fred Rispoli provides an overview of the appeals procedure in the continuing legal dispute between Ripple and the SEC. The appeals process consists of two primary appeals, the appeal filed by the SEC and the cross appeal filed by Ripple. This article explains the significance of these appeals and outlines what to anticipate in the coming months. During an appearance on the Good Morning Crypto show, Rispoli explained that this case involves two separate appeals. Ripple's cross appeal, titled after the fact that it was submitted after the SEC appeal, is the second appeal. The first appeal is the appeal that the SEC has filed. The arguments that each side will provide will be organized in a specific manner. Oral depositions in the courtroom. In most cases, the process of appealing a decision involves several steps. In the beginning, the party that is appealing will present their opening arguments, and then the party that is opposing them will answer with their opposition brief. Following that, the party that initially appealed will have the opportunity to respond. A motion, an opposition, and a response are the three components that make up this framework, which is comparable to the formation of motions in trial courts. It is scheduled that oral arguments will take place after the briefs have been submitted. In the course of these arguments, the case will be heard by a panel consisting of 3 judges. Each party will only have 15 minutes to deliver their reasons, and the session will be aired so that the whole public may observe it, even though the written arguments are the most important. The questions that the judges ask during this brief session will also provide important information. There is a possibility that the judges' preferences can be inferred from the questions that they ask. If the judges put a lot of pressure on Ripple by asking them difficult questions, it could be an indication that they are not favoring their case. On the other hand, if they concentrate more on the SC key and ask them important questions, this could indicate that Ripple has a bright future ahead of it. Even though the oral arguments and brief filings would appear to be completed in a short amount of time, Rispoli stated that the whole time frame for the case could take up to a year and a half. This drawn-out procedure is typical in the legal system, where even a brief hearing can result in a lengthy period of discussion. There was a brief period when XRP fell below the psychologically critical 50 cents threshold after the Form C filing that took place on October 25. However, it quickly recovered the next day and is currently trading over 51 cents. Since the beginning of the month, the token has experienced a decline of 15%, going from a value of 61 cents to its current value of 51 cents. As a result of the announcement that the Securities and Exchange Commission was going to file a notice of appeal in its ongoing litigation against Ripple, which challenges Judge Tor's decision that XRP is not a securities, the price experienced the most significant decrease on October 3. The general market sentiment surrounding the token appears to be uncertain about where it stands in the absence of favorable developments in the SEC v. this. Ripple case, this is even though XRP bulls may be anticipating a rebound when the case is still ongoing. The never-ending legal dispute over the legality of XRP appears to be putting investors on edge. This is because both parties have since appealed parts of the verdict that was issued in August 2023. At the same time, holders of XRP are not in a hurry to liquidate their holdings while they wait to see how cross appeals would play out for both parties. As of October 28, the most recent exchange inflows were just $10 million as reported by CryptoQuant. This is a significant decrease from the maximum amount of $15 billion that was recorded on October 20 of this month. Based on the statistics, it appears that a significant number of investors may have adopted a wait-and-see strategy rather than giving an immediate response to every legal update. The quantity of cryptocurrency, such as XRP, that is being moved to exchange wallets is tracked by exchange inflow, which is a valuable statistic for measuring market mood because it records cryptocurrency transfers. In most cases, the presence of significant quantities of cryptocurrency entering exchanges is indicative of holders being ready to sell their holdings, which could result in a decrease in the value of the asset. Considering that the majority of selling pressure was expended earlier this month when the SEC filed a concept of appeal, the current modest inflows signal that more investors are now determined to hold on to their current positions. Additionally, the relative strength index indicates that the selling pressure is decreasing, which presents an opportunity for XRP to experience a possible price increase. Therefore, an upward reversal is not completely out of the question if the metric falls below. The present RSI is 38, which is only slightly above the threshold that indicates that the market is oversold. For the time being, it seems that XRP may still be subject to some selling pressure, and the bottom may be still waiting to be reached before the bullish turnaround occurs. In cryptocurrency trading, the relative strength index ERSI is one of the most often utilized indicators for determining whether a market is oversold or overbought. The indicator is a representation of an oscillator, and it takes values in a range that goes from 0 to 100. Values that are lower than 30 indicate that the market is oversold, while values that are higher than 70 indicate that the market is overbought. Take a look, come along with us as we demonstrate the transformation brought about by cryptocurrencies, one newsletter at a time. Join our millions of other subscribers and receive daily news and market updates delivered directly to your inbox by subscribing to our newsletter right now. Ongoing legal battle. Ripple's appeal ushers in a new phase of the conflict. In a message that was published on X on Friday, Ripple's chief legal officer, Stuart Alderati, revealed that the business has submitted a Form C to the United States Court of Appeals for the Second Circuit to appeal certain aspects of the verdict that was handed down by Judge Torres. In response to the notice of cross appeal that was submitted by the corporation earlier this month, this maneuver was taken. The conclusion of the court that the business's institutional sales of XRP constituted an unregistered securities offering, which resulted in a punishment of $125 million for the company, is being challenged in the appeal. Howey's test is a framework that was developed by the Supreme Court to examine whether a transaction qualifies as an investment contract. Ripple expressly disagrees with the court's use of this test. In addition, the business contends that Judge Torres failed to take into account the far greater regulatory uncertainty that is associated with the application of securities laws to digital assets when she rendered her ruling. In addition, Ripple asserts that the SEC did not offer a reasonable notice that the sale of XRP violated the aforementioned statutes. The submission makes a request for a de novo review of the case, which means that the appeals court will re-examine the case. This means that the court will not rely on the facts or conclusions that were reached in the earlier examination. Alderati underlined that the State Securities and Exchange Commission's appeal does not challenge the conclusion of the district court that XRP itself is not a security. This result continues to be a significant victory for Ripple. While we are going through this process, you must keep in mind the larger approach that the SEC is employing, which is to try to cause diversion and uncertainty for Ripple in the industry. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page.